For more on this case, I want to bring in Hans von Spakovsky. He is a senior legal fellow and manager of the Election Law Reform Initiative at the Heritage Foundation. Thanks so much for joining us.
Sure, thanks for having me.
The Supreme Court previously upheld parts of the Voting Rights Act in similar redistricting cases. How does this Louisiana case differ, and what legal precedent could the court be setting if it limits the use of Voting Rights Acts here?
Well, everyone keeps claiming that they might throw out Section 2 of the Voting Rights Act. That's just not what's going to happen. The problem in this Louisiana case was a federal judge misinterpreting and misapplying Section 2. Race is only supposed to be used in drawing up a district if there's a Section 2 violation. A Section 2 violation means that there's evidence that there's been racial discrimination that needs to be remedied. In this case, a judge issued an order telling Louisiana you have to draw up a second district. There wasn't any evidence of racial discrimination by the legislature. They simply said, well, black voters are a third of the population, therefore they deserve 2, not just 1 of the 6 congressional districts. That actually violates Section 2 because Section 2 says it does not entitle anyone to proportional representation. And Louisiana did what the judge said, but then they got sued by a second set of voters who said, listen, when you drew up that second district, you used race, and that's a violation of equal protection. So what the court has to do is decide if and when can race be used in redistricting without violating the 14th and 15th Amendments of the Constitution.
Now, some argue that the Voting Rights Act gives the federal government too much influence over how states draw their electoral maps. How does this case reflect the ongoing tension between states' rights and federal oversight in elections?
Well, again, I think folks are looking at this the wrong way. Look, what the Voting Rights Act does, Section 2, is to carry out the requirements of the 14th and 15th Amendment, which say you cannot discriminate on the basis of race in the voting context. The problem has been that the law has been misinterpreted and misapplied by federal judges who fail to distinguish between redistricting done for racial purposes and redistricting done for political purpose. And in fact, the Deputy Solicitor General for the Justice Department pointed that out today in the oral arguments.
How do you think this ends?
I think what will happen is the majority of the justices will issue rules clarifying how and when Section 2 should be applied and limiting the use of race in redistricting only to cases where you can show there was intentional racial discrimination by a state legislature.
Hans von Spakovsky, thank you so much.
Sir, thanks for having me.